Hi, and welcome back once again to Employment Hour in 30. I'm John Scholes. With me, Lior Samfiru, the owner and the big guy, Samfiru Tumarkin Law Firm. And we're giving you the knowledge, the employment rights you didn't even know you had. That's the basis of the show each week. Lots of stuff to cover today. The Severance Pay Calculator. We'll also get to the worst times for an employee to terminate an employee. Some of these are going to sound familiar either with yourself or with friends or family. That is all coming up. We'll get to your phone calls, terminationquestions.com. A plethora of stuff to go through today, Lior, but we always start with the week that was, some cases you've been working on at the firm, some things that would be of interest to our viewers. So what do you got going on?
Well, a lot of things actually going on. I've spoken with a lot of people over the past week, a lot of people that actually watched the show and realized that now there's some help, some things that they can do about their legal rights in the workplace, and that's great. That makes me so happy to know that we're getting through to people. We're able to send a message out that the employment laws here in this province, in this country for that matter, are good. They help employees. They ensure that employees get what they're owed. So if you have a workplace problems, there's usually a solution. So give me a call, send me an email. We'll give you my contact information a bunch of times throughout the show today. And let's talk. Let's make sure that we can help you dealing with any problems that you have. And as you said, John, I always like to get us warmed up with a story, something that came across my desk over the past few days. This situation involved a gentleman that was hired as a plant manager, and he worked for a company for 6 months. After 6 months, the company decided, you know, it's not really working out for us. Fair enough, and they let him go. Yep. And to let him go, they said, we're going to give you 3 weeks' pay. Now, he had contacted me, and he told me a bit of a story. He said that I was working for 15 years at another company. I was happily employed. I wasn't looking to leave. They came to me through a recruiter. They said, we think you have exactly the experience that we need. They ended up making me such a great offer, I couldn't say no, even though I wasn't looking to leave. And then I took this job, and of course, 6 months later, they let me go because I'm not the right fit. What does this mean? I lost that job that I had for 15 years. Well, here's the thing. Obviously, he gets severance. So we start with the proposition. The question is, how much severance? Now, he'd worked there for 6 months. But because of the fact, John, that he was recruited from another company, that he was securely employed and not looking to leave, he now is owed enhanced severance that accounts for his time with the previous company. So even though he only worked for the company for 6 months, he's really considered a 15-plus year employee because of the past service. So the severance that he's going to be owed is going to be anywhere from 14, 15, 16 months of pay, even though he only worked for 6 months. So I want our viewers to understand that if you're being recruited away from another job, you're hired despite the fact you weren't really trying to leave, and then you're let go, you could be owed much more severance than you realize, a lot more. Now, last comment I'll make on that, John, is even if he was only a 6-month employee, he would still be owed a lot more than 3 weeks' pay. He'd probably be owed 4 months' pay, even 5 months' pay. So either way, the company's offer of 3 weeks' pay was completely inadequate. Again, not surprising, 90% of the cases that I see come across my desk every single day, people are offered pennies on the dollar when it comes to severance, a lot less than they're owed.
That's, we refer to that as an inducement when it comes from another company. Now, he had 15 years there. He had a 6-month term, which is relatively short. Where do you draw the line where it no longer becomes part of your 15-year service? I mean, if he works there for a year, 2 years, 5 years down the road, when does that no longer count?
Usually, I would say if you worked for the new company for about 3 years or more, after that point, we're not really going to account for your past service. But in the first 3 years, yes, I always want to know, how did you end up working for this company? Did you apply for a job, or did they come after you? Right. If the company came after you, convinced you to take this job, you're working somewhere else, and then they let you go, let's say in the first 3 years, you absolutely may be owed significantly more enhanced severance. If you haven't caught it, we do the Employment Hour live radio show for about the past 5 years. You want to find a station near you where you can listen to the show, carry the show, podcasts or otherwise, employmenthourtv.ca. We like to air some of the calls we get on the radio show because they are of interest, and we'll get to one right now.
I've been with the company for, say, about 14 years doing the same job, give or take, but the same shift. So work is a bit slow, so for them to find work for me, they're putting me on an afternoon shift where I've been working days. If I refuse, do I have recourse for severance?
Yeah, pretty common question.
Very common question. And, I can understand it from the company's perspective. Obviously, if they need to make a change, they may want to take someone from a day shift, put them on a different shift. But whether I understand it or not, we have to put that aside. We have to talk about what the law says here. And the law is very clear. that an employer is not allowed to make significant changes to the terms of employment. That absolutely includes changing your shift.
Right.
So if you're working on a day shift and now you're going to work a different shift, afternoon shift, night shift, that's a big deal. That's a significant change, which means if the company is going to impose that on you, if they say, we've made the decision, you're working a different shift, the employee may be able to treat that as a constructive dismissal, saying, no, I'm not going to accept that, and I'm going to leave with my severance. Now, one thing I would want to know is this something that's happened in the past?
Right.
Did they make him work the afternoon shift in the past and then they put him back on day shift? Because if they've done that in the past, arguably because he let them do it, they can do it again. If he opened the door in the past, they may be able to go walk through the door now. So I'd like to know that. But if they hadn't done that before, if it's the first time they want to change a shift from day shift to afternoon shift, he absolutely can say no. He doesn't have to accept it. And if they insist, if they try to do it anyway, that's a constructive dismissal. And that, by the way, doesn't just apply to changes in shifts.
I was going to say, what else does that qualify for?
Any significant change. So compensation is the big one. Obviously, if your employer is going to reduce your pay, that's a big deal.
Location, maybe.
Location.
Yeah.
Now you instead of taking 20 minutes to get to work, you're going to take an hour to get to work because of the new location. That's a big deal. Or maybe you were demoted. Some situations you may be demoted without a change in pay, but you're taking a position with lesser responsibility. Maybe you were a manager, now you're not going to be a manager. Even if they don't reduce your pay, John, that could be a constructive dismissal. So if you're faced any significant change in the terms of employment, give me a call. And you don't want to just accept it. You don't want to try it out for too long. If you try it out for too long or just accept it, you're stuck with it. And then you can't do anything about it. And you give the right to the employer to do it again. That's bad news.
I was going to mention that if he decided, maybe the shift wouldn't be so bad, maybe it would be better for my lifestyle, could he try it out for a bit or take it for a spin? And what's that, 2 weeks, 3 weeks? How long can he go without saying, it's yours, you own it?
Well, first thing I would want him to do is tell his employer that that's what he's doing. Now, I'm going to try this out. I'm not agreeing, but I want to see how this impacts my life and if that's even manageable for me. And then once he does that, I would try it in a situation like this. A month would be fine. If he tried it for a month or so and see if he could do it, if it fits in his lifestyle. And if after a month he decides, no, this is just not workable, as long as he's told his employer that that's what he's doing, he can say, no, this is not something I'm accepting, and if you're going to make me, that's a constructive dismissal.
1-855-821-5900. That's the number anytime to get a hold of Lior, another member of his team when the show is not on. There's also a way you can ask questions anonymously other than email. That is terminationquestions.com. You ask them, and there's a drop-down menu. It's a pretty good chance that your question has already been asked and answered at length. If not, you can leave it there, and Lior and a member of his staff will get to it. I'll read one right now for you and let you expand on it. This again from terminationquestions.com says, after a car accident 3 years ago, I went on LTD, long-term disability. My insurance cut me off last year, and I've unsuccessfully appealed 3 times. After the 3rd appeal, my boss fired me. She said because the insurance company said I was no longer injured, she legally didn't have to keep me on any longer. How do I get my job back?
It's a great question. So let's break this into 2 parts. Let's talk about the insurance company first, the long-term disability insurance company, and then let's talk about the employee and employer situation. So first of all, John, it is a waste of time to appeal a long-term disability denial. You're appealing to the same people that already have denied you. They're not going to change their mind 99 out of 100 times. It's a waste of time. And to do it 2 or 3 times, it's even a bigger waste of time. Unfortunately, in the situation where the insurance company denies you, the only way to get it resolved is to give us a call, to have us do what we do, which is deal with the insurance company and make sure that they abide by their legal obligations. The good news is those issues are easy to resolve. So to this person, I'd say, let's first deal with your insurance company. Let's get them to change their mind and pay what you're owed. And sometimes a letter from us would do it. Sometimes it needs something more than just a letter. Either way, give us a call. We deal with that all the time. But in terms of the employer, just because you've been denied disability by the insurance company, right or wrong, doesn't mean that the employer can say, well, too bad, you have to come back to work or else. Here's the thing, John. As long as your doctor is saying you cannot work, I don't care what the insurance company says. I don't care what it says. Whether the insurance company wants to pay you or not, that's a separate issue. If your doctor says you can't work and you provide that note to the insurance company, they can't fire you, they can't consider you to have resigned. You're allowed to be off work as long as needed, as long as that's what your doctor says. It could be a week, a month, a year, or longer. So have that doctor's note. Have your doctor say you can't work, maybe even give an estimate as to how long you may be off or when you'll be evaluated again. And if your employer says that's not good enough, or if your employer says, well, that's not what the insurance company is telling us, give me a call. Get them off your back. Now, in terms of getting your job back, usually there's no way to get your job back. In some situations, we may be able to. In most cases, it's a matter of compensation. How much compensation can we get you because they improperly let you go? So give me a call if that ever happens.
And a pleasant little sidebar to that is once you guys get involved, the insurance company can no longer call you and hassle you. They have to go through your firm,
right,
which is great.
Yeah, you know, I always like to be, I would like to be a fly on the wall. When the insurance company gets one of our letters, they probably shake their head and say, oh, crap, except
here we go.
Probably use a different word.
Right.
Because now they know we've called them on their behavior. Now they know that it's going to be dealt with properly. So yeah, we take that issue off the table. You don't have to deal with the insurance company. You don't have to deal with getting letters and phone calls. Have us do our job. We have a whole team at the office that exclusively deals with insurance issues, disability issues. So put us to work.
Help@employmenthour.com is the email. I mentioned off the top of the show as well, we're going to talk about the worst times for an employer to terminate an employee. We'll get through a list of these and let you answer them as we go. Number one, when an employer asks about taking a disability leave or comes back from a disability leave, you can't be let go.
You can't. Now, by the way, John, any employee that's been let go, they're probably always going to say that's the worst time because I have bills to pay, I wasn't expecting it. So it's never a good time to be let go. That said, there are times that are specifically problematic for the employer and when an employer should not let an employee go or at least expect to pay a lot of money. And one of those situations, as you said, is if an employee is taking a disability leave, asking about a disability leave, or coming back from a disability leave. And the reason why that's problematic is if your employer lets you go because you're taking a disability leave, that's illegal. That's a violation of the Human Rights Code. Doesn't matter how much severance they're willing to pay, it's still illegal. So an employee has a right to be off work as long as needed. They can't be penalized because they're going to take a disability leave. I've seen situations where an employee may go to the employer and say, I'm about to have knee surgery and I'm going to be off for a couple of months. The employer says, well, that's too much of a disruption and lets them go. Can't do that. It's illegal. So if your employer lets you go in that situation, when you have a disability, you're about to go on a leave or you're coming back from a leave, the law's going to come down pretty hard on the employer. There could be human rights damages to pay over and above severance. So if that happens, you know how to do. You know what to do. Call me.
Another bad time, in fact, the worst times for the employer to let you go is when an employee raises harassment allegations either against a coworker or a boss. This has been all over the news, of course, for the last 4 or 5 months, right?
Yeah, and terrible idea, especially now, but really always. You have a right to have a poison-free work environment, to have a proper supportive work environment. And beyond that, you have a right to raise allegations of harassment. You have a right to go to the employer and say, I have this problem. I'm suffering from harassment. Do something. Investigate and fix the problem.
They have to.
And they have to. And not only do they have to investigate and fix the problem, they can't penalize you. And you have almost this cocoon of protection around you that the law imposes. So the law wants to encourage people to raise these allegations. And it does that by making sure that people know that nothing bad can happen. Even if you can't prove the harassment, even if the company concludes that there's no harassment, they can't punish you for it. So if the company tries to do that, there could be human rights damages, there could be damages under the Occupational Health and Safety Act, under the Employment Standards Act. It's wrong, it's illegal. If that happens, trust me, the employer's going to have to pay.
1-855-821-5900 is the number to get a hold of Lior and a member of the team. Talking about the worst times for an employer to terminate an employee. And if you're an employer, listen up to these because they concern you big time. Number 3, right after you reduce employee compensation or get them to sign a new contract of employment. There's a big one.
I put that on the category of an employer's trying to be clever. So the employer may think, well, let me have the employee sign an employment agreement that limits their entitlements and then let them go. Or let me reduce their pay and then let them go because now I have to pay less severance. So if the employer reduces someone's pay in bad faith or has someone sign an employment agreement in bad faith because all along they're thinking, I'm going to let them go and save a bunch of money, that's wrong, and there's going to be bad faith damages that have to be paid. So an employer should not try to take advantage of the employee's vulnerability to save money on severance. That's illegal, improper, and the law is going to come down hard on the employer.
Worst time for employers to let go of employees. This one matters big time to people in the sales industry that work on commission. That is right before an employee is due to get a large bonus or a commission from a job.
Well, think about it. I worked hard. I did a really good job. I earned a commission or I'm owed a bonus. And what does my employer do a week before it's due? Yeah, you're gone. Oh, unrelated, of course.
Of course.
Well, guess what? That doesn't work. And think about it. If that was the case, no employee would ever have an incentive to do a good job, right? So think about the message that may send to the employees because they'll think, Bob was let go before he got his bonus, so why should I work hard and get this bonus because they're going to let me go as well? That's bad faith. And not only is the employer not going to save money on the bonus, they're going to have to pay that bonus. They're going to have to pay that commission. There may be additional penalties and punishments for the employer because they're acting in bad faith.
Last one we'll get to for this particular segment. That is the worst times for an employer to terminate an employee. This one's the big one, and people should know better by now, but we keep talking about it for half a decade. That is when an employee announces a pregnancy or comes back off of maternity/paternity leave.
This should be obvious, so I'm not going to
on the mug
elaborate.
yet? Don't mess with mama? No,
No.
It's not there yet.
We'll get mugs next week.
That's right.
But the reality is this is obvious, John. This is basic. This is one of the most simple, basic, fundamental tenets of employment law. You can't penalize someone because they're taking maternity leave, parental leave. You can't punish them, discipline them. You can't avoid hiring them back. You can't decide that you like their replacement better. If you do that, that's a human rights violation. That's illegal. That's all I'm going to say about that.
Ken, is there any chance that what does an employer do if they end up liking the person better that they've had for the temp?
Well, the technical term is too bad. No, it really is. You can't decide that. You can't do that. You can keep both if you want,
right,
but you can't decide that you're going to keep the replacement over the person that's on maternity leave. So what you do in the workplace in terms of making changes, it's up to the company. But you cannot decide not to bring the person back from maternity leave because you like the replacement better. Can't do it.
The truth about severance offer deadlines and the severance pay calculator at severancepaycalculator.com. Those details coming up after a short break. 1-855-821-5900 and help at employmenthour.com as well. Take a short break. Be right back.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact, the labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com.
Anytime you want to contact Lior, employmenthourtv.ca or 1-855-821-5900. Another amazing tool. If you haven't used it, it takes about 30 seconds, really quick. You won't even finish your coffee by the time you're done. It's SeverancePayCalculator.com. Find out what the severance should be that you're being offered, or just for information's sake, you could do it as well. Give me some details on it, pal.
SeverancePayCalculator.com. I've created this tool myself a few years back, and I created it because I identified that there's this gap in information out there.
Yeah.
You want to know how much you're owed. Oftentimes you may go online and you read something on the Ministry of Labor website that only tells you about your minimum entitlements, which is a small fraction of what you're actually owed. So I created the Severance Calculator, and it allows anyone to find out in seconds, literally in seconds, how much they're owed. And there's no strings attached. It's free, it's anonymous. You go to SeverancePayCalculator.com. Again, it's SeverancePayCalculator.com. You answer 3 simple questions: age, position, length of employment. That's it, you're done. There's nothing more to it. And you find out how much you're owed. Now, it doesn't just work if you lost your job. Maybe you're curious or worried about losing your job. Or you know someone else that lost their job and they need to find out how much they're owed. SeverancePayCalculator.com. It's the only way to do it, and it works all the time. There's no bug in the system. I know we always like to joke about the fact that people look at it and say, holy cow, I'm owed 16 months severance. I thought I was owed 8 weeks. No, there's no bug in the system. It's what the law provides for you. So try it out. You know, have some fun with it. You may not lose your job or never lose your job. Maybe you're just curious. You want to know what if. SeverancePayCalculator.com.
Make it a home game. There's also an employer mode, so if you're an employer, you can use that in advance of possibly having to let someone go. You're going to know what the proper amount of severance is too, right?
Absolutely. If you're an employer that wants to comply with your legal obligation, doesn't want to have a wrongful dismissal claim on their hands, go to SeverancePayCalculator.com. There's an employer mode. Again, it's free. There's no strings attached. It's just to help employers and employees understand their rights and obligations.
We'll run through a quick scenario using the Severance Pay Calculator. I took a day off work last week to battle a cold, but my new manager thought I was simply trying to avoid work and decided to fire me. She did offer me 7 weeks of severance for 6 years of service. Here's the kicker, but with one rule. For every day I fail to accept that offer, she will remove 1 week's pay from the total.
Yeah.
That's
wow.
right.
That's original. You know, get points for originality on that one. I'll give her that. So let's start with the fact that obviously if you we're sick with a cold, you can't be fired for cause. So if the company wants to let you go, they have to pay you severance. And 7 weeks is not even close to being enough. So it's not that you have to worry, oh my God, the 7 weeks is going to be reduced to 6 weeks. That 7 weeks is nonsense. So how do we know it's nonsense? Well, I told you, but you can find out yourself. So let's apply that and put that in the severance calculator. So let's put it in a position. I picked supervisor just as an example. 6 years of service. We don't know their salary, but they're offered 7 weeks pay. Well, severance calculator correctly says that the person is owed about 8 months pay.
She's a little off.
A little off. So can you imagine someone may be stressing out over 7 weeks pay? Should we accept this when they're owed 8 months pay? So that we took that right off the severancepaycalculator.com website. You can do that yourself. And that's why I wanted to show it, because it's a perfect example of why so many people don't understand what their rights are. People get afraid about these deadlines. Oh my God, if I don't accept it, I'm going to lose something, when the offer was terrible to begin with. Yeah. So severancepaycalculator.com, check it out. You'll be happy that you did.
EmploymentHourTV.ca as well to find out where you can catch the broadcast, our radio show for about the past 5 years we've been doing. We take a ton of phone calls on the radio show. We'll get to another one now. Might be of interest to you.
What's the basic amount of time for someone to be eligible for severance pay? Because, for instance, during the training period of employment, that's 2 months, and then they put some people on layoff. I've noticed that layoffs only means 6 months before a person can reapply again if they're still interested in working at that place.
There you go.
Right. Well, let's start with the proposition that you actually have 2 years to pursue your legal rights. Now, when we talk about layoffs, there's a question of what we're actually talking about. There's a temporary layoff where the company plans to bring you back over a certain period of time. And remember, the company doesn't actually have a right to lay you off temporarily. You can treat that temporary layoff as a termination, as long as it hasn't happened before. So the first time the company wants to lay you off temporarily, usually you can treat that as a termination and say, no, I'm going to get my severance. But if we're talking about a permanent layoff, well, you don't have to reapply for your job. The moment the company lets you go, at that moment, your rights to severance have crystallized. You're owed that severance. So as long as you do it within 2 years, you can pursue it, of course, if you haven't signed off on your severance package. So 2 years to pursue it. And remember, a temporary layoff is, in fact, a termination.
We're going to talk about working with an American employee, how that affects your employment laws, as well how working notice works after a short break. 1-855-821-5900 is help@employmenthour.com as well. Back to Employment Hour in 30.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact. Over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. Severancepaycalculator.com. Accurate, anonymous, and free. Severancepaycalculator.com. Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact. In most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first.
And welcome back to Employment Hour in 30. The radio show happens. You want to find out where, how you listen to it, go to employmenthourtv.ca as well. Take a ton of phone calls on the show. We got great callers calling through, wonderful questions, and we'll play another one for you, have you answer it as well.
What could someone expect in Ontario for severance pay for 15 years of service, white-collar executive, 40? When they give you a separation agreement where they extend the period of termination and they state that, we'll employ you for the following 2 months, if you should leave before then, are you still entitled to that separation pay that they initially promised, or are you at risk of losing that if you had found gainful employment?
A little bit of math in there.
Yeah, a little bit of math. So let's talk a bit about that. Okay. So first of all, as I understand this situation, this person is being let go, and the company gives them 8 weeks advance notice. Now, a company is allowed to provide advance notice, and that notice, John, counts towards the person's severance. So if you're owed 12-month severance and the company gives you 2 months notice, well, then you're still owed another 10 months at the back end of it, at the end of that notice period. So that's important to understand. And the other question here was, if I quit during that notice period, so they gave me 8 weeks notice of termination, and I quit before then, do I still get severance? The answer is no. If you quit before the last day of employment, before the company says you're gone, then that's a resignation, which is fine, but you don't get severance. But here's the real question. The real question is the
enough?
8 weeks enough?
Right.
So rather than me tell you, I could, but I like the severance calculator. Again, severancepaycalculator.com. So let's take that and input it into the severance pay calculator and see what we get. So this person said he was an executive, 15 years of service, age of 40, and he was given 2 months notice. In other words, 2 months severance. Same thing. Well, he's really owed 15 months of notice or severance. So the company still owes him another 13 months at the back end. They gave him 2 months notice. They owe him another 13 months severance at the back end for a total of 15 months. So this person may think, oh, 2 months is all I'm owed. The notice that I got is all I'm owed. And they're owed another 13 months pay, John. So severancepaycalculator.com, that's where we took it. You can do the same thing yourself at home right now at severancepaycalculator.com. And if you don't, you may end up realizing when it's too late that you've accepted tens of thousands of dollars less than what the law says you should have.
Still scratching your head, have questions swirling around in your head, place to answer them, or at least ask them and have them answered is terminationquestions.com. You want to lay it out there, and a member of Lior's team or Lior himself will answer it again online to terminationquestions.com. I got one here that says, I've worked at a U.S.-based company for 30 years. They just announced that our office in Toronto will close, and we will be moved to Cambridge, doubling my commute to 90 minutes one way. Do I have to accept that? What are my options? Do I even have any because the company is American and observes American employment laws?
Great, great question. But you and I are kind of smirking because we know the answer. We've talked about these issues before. So let's start with the American part. So a lot of people may work for a foreign company, or it doesn't have to be American. It could be European or Asian, what have you. If you work in Ontario, Ontario laws apply to you. It doesn't matter where the company is headquartered. It doesn't matter who you report to or what the company wants to apply. Ontario laws apply to anyone working in this province. Some employees may be regulated federally, but it's Canadian or Ontario laws that apply, always, no exception. So you work for an American company doesn't change that. So now we know that. Let's talk about this change in commute. If your commute now is doubled and you're going to be commuting 90 minutes one way, that's a big deal. That changes your whole life. And of course, that's a constructive dismissal. So if your employer is going to change your commute in this way, as in this example that we just read, you absolutely don't have to do it. You don't have to commute the extra 90 minutes or whatever it is to get to work. You can say no, leave and get your severance. So American, Canadian company, European or Asian, it doesn't matter, all works exactly the same. Ontario laws apply, constructive dismissal applies. Now, what I don't want this person or anyone else to do is to quit before speaking to me, okay? That's putting the cart before the horse. If you want to quit, or if you think something's happened, a change in the workplace has happened that you don't want to accept, that's fine. Call me first. Let's talk about how we quit, what we say when we quit, so I can hold your hand through that process, and only then can you go ahead and do it. So call me first, quit second.
And again, don't accept it right away, because if you do, now they can move you 2 hours away and you've accepted it, right? It goes
Can
back
you
to that
imagine?
scenario.
Yeah, if you accept this one relocation, what happens when they relocate again? And this time it's 2 hours or 3 hours. Bad idea. Then you're stuck with it. So you want to do something about it as soon as the change happens.
Give it to me one more time as we get down to the last couple minutes here. Severance Pay Calculator, if people missed it.
Well, John, the whole idea behind us talking about employment law, which was before this TV show, we've been doing a radio show for 5 years or so. The idea was to inform people about severance. Now, we talk about a lot more than severance here, but because I realized this gap in people's knowledge when it comes to severance, I wanted to do something about it. Every day I'd get calls from people that were offered a lot less than they're owed, and a lot of people that realized a year later, or 2 years, or 3 or 5 years later, when it's too late, that they're owed a lot more money. And I wanted to do something about it, so severancepaycalculator.com is the easiest way that I know to give that information to people, free, no strings attached. I don't need anything from you, just to make sure that you're informed. Severancepaycalculator.com.
And we're going to be getting close to 500,000 people use that particular program pretty soon.
I'm very proud of that, and onwards and upwards. I want to get to 1 million and 2 million and beyond.
Again, ways to contact terminationquestions.com. You can ask your questions there, and they'll be answered by Lior, member of his staff, anonymously. help@employmenthour.com is the email address, and as we just mentioned a few times during the show, just try it. You've got to try it, even if you don't need it right now. Hopefully you don't ever, but you might one day. Severancepaycalculator.com. And the number, as always, 1-855-821-5900. And make sure you go to employmenthourtv.ca. You want to find out where and how to listen to our radio shows. Till next time, it's been the Employment Hour in 30, right here.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.